Hello? Hello?
Good morning.
Okay. Just want to make sure I'm still on the line.
Yes, sir, you're still on the line.
Okay. Are we waiting for people yet?
Yes, sir, we are.
Okay. Thank you.
Calling case 210540 LT, David Brown versus James Chapman. This landlord-tenant matter was scheduled for hearing today, February 26, 2021 at 10 a.m. Notices were issued to the parties. The court's Zoom courtroom has been open and active since 9:45. The court just received notice that the defendant is having trouble connecting electronically. It will give him a few more minutes to try to connect, otherwise the case will be called and the hearing will proceed.
Oh, Civil, Mary Ann.
All right, I'm gonna let you guys go now since you're here, okay?
Thank you.
Thank you.
Yep. Bye-bye.
Thank you.
Good morning, Mr. DePietro and Mr. Chapman.
Good morning, Your Honor.
Mr.
Yes.
Brown is already on the line. I called the case at 10:15. I wasn't sure what the issue was. I'll recall 210540 LT. Your appearances, please.
Good morning, Your Honor. Tom DePietro appearing on behalf of Mr. Brown.
James Chapman appearing pro se.
And Mr. DePietro, your client's also on the line.
I have two other witnesses that we're trying to get in too, Judge, and apparently there's some kind of snafu with regard to getting into the meeting room. Mr. Chapman had a problem this morning and showed up on my doorstep, which is why he's sitting here next to me, with your permission. And I witnessed him attempt to get into the system with his phone, and it was a failure. So I asked the gal to just let us both in on the Zoom, if that's okay with the court.
Understood.
We also have, there's two other witnesses. I don't know where they are. I gave them what I thought was the applicable code number. I don't know what their status is. I haven't got any phone calls from them, but I may need to make a phone call at some point, Your Honor, with your permission.
These were the witnesses you anticipated needing to establish an escrow amount?
One of them was. The other
Okay.
one was to go to the issue of whether there should be a trial at all and whether the court should enter a judgment based on the pleadings and the argument.
Your Honor, I'd like to give a tentative proposition to dispose of this case.
Is that something that I was going to ask if you, Mr. DePietro, and Mr. Brown needed to speak in a breakout room? Is a resolution possible this morning?
I have a proposition.
Judge, will you tell him to put his mask up?
Mr.
I
Chapman,
can't breathe. My doctors told me not to wear a mask. And
I understand, Mr. Chapman, and I'm respectful of any medical condition you might have. However, Mr. DePietro has let you into his office and he's making a request of you. Part of the reason why we adjourned this matter from last week was that there were a couple of outstanding issues. First, that escrow could not be established because there had not been a prior rental payment history as far as the court could ascertain. That was number one. And number two, Mr. Chapman had in fact made a timely demand for a jury trial. When I adjourned the matter, my hope was that the parties would either resolve it or that there would be a way to value the rental rate that should be used in any order for escrow. So that having been said, if the parties are not inclined to speak and the resolution is not possible this morning, Mr. DePietro, if you can get your witness ready for the entry of an escrow order, the court can do that. Or if you would prefer to start with the issue of any tribal issues remaining for the court.
Well, first of all, if I might say, Your Honor, it was my impression from our last meeting that you were willing to entertain that type of motion today. If I was mistaken, then I'm perfectly happy to proceed as the court directs, going directly to the escrow.
I am willing to entertain the motion as much as the court rules indicate that a judgment will enter if there are no tribal issues. And if that's where the parties are, and the parties don't need to speak this morning, I'll hear your argument, Mr. DePietro.
Would you mind kicking us off into a room for a minute so that I can ask Mr. Chapman what it is he's talking about in terms of resolution and make sure I've got my witness handy?
Do you need your client for a breakout room?
Yes, Your Honor.
Okay. I will assign you to a breakout room.
Sorry for all of this. I didn't anticipate this procedure.
I didn't either.
I'm sending you now.
Hit join.
You'll see the invitation to hit join.
Oh, very well. Thanks, Judge.
Thank you.
Hey, Judge.
Yes, ma'am.
Well, it's just us in here. I wanted to ask you a question. real
We're
quick.
streaming live on YouTube, so
I was just wondering for next Tuesday's docket, the 2nd, if I could also join in so that I can live dispo at that time.
it's perfectly fine.
Okay, I just wanted to make sure with you. Thank you.
On my electricity, on my computer. Oh,
Mr. DePietro,
yes, Judge, the discussion was unfruitful.
He didn't get a chance to reply.
That's correct. I didn't let my client reply because it would have started a series of unproductive discussions, Your Honor.
understood.
May I also indicate to the court that my witness had trouble getting in because the Zoom number changed from the one I gave him, so he might be coming in, Mr. Sylvanus. The other witness is Gene Carrier. He would have applied to the issue of whether a judgment should enter, but perhaps the court wouldn't want to hear that anyway, moving into facts. I don't know, but he's available. If I might suggest, Judge, I'd be allowed to make an argument with regard to why a judgment should be entered for possession, and then, depending on the court's feelings, move on to the escrow.
I do believe that's the most prudent path to take.
Thank you, Your Honor. I would indicate, Your Honor, that the pleadings establish that there was a tenancy or a voluntary possession given at some point, and that it's the intent of the landlord that terminate. There is no lease, so 30-day notice was given as required by statute and by the Landlord Tenant Act, and it is my client's continuing desire to terminate that tenancy. We alleged in the complaint that the use of the premises was contrary to the ordinances of the city of Belleville. Also, excuse me, Judge, I had submitted, pardon me. Mr. Sylvanus has just appeared, Your Honor.
I did admit him, but Mr. DePietro, I'm listening to your argument.
Thank you, Judge. Also, I submitted an exhibit to the court. I believe it was a proposed exhibit 1. I have Mr. Chapman here with me, and I have given it to review. I would offer this exhibit for the purpose of establishing what my client believed at the time he continued to pursue this eviction. For example, Judge, I think some of the email would appropriately be excluded as hearsay. However, in anticipation of counsel's objection on that basis, I need to see it while I'm talking. I would direct the court's attention to the 3rd paragraph from the bottom, which starts with "I advised." Does the court see that reference?
I do.
Okay. I would offer this document for the purpose of admitting that sentence into the record, for the purpose of showing its effect upon my client with regard to his motive and desire to continue to pursue this matter and to pursue this matter. The statement is not being offered to prove the truth of the matter asserted in the statement, therefore it is not hearsay. Rather, it is being offered for the purpose of establishing that my client, it affected my client. And there's a couple of cases, Your Honor, that deal with a statement being offered for the purpose of showing its effect on the listener. One of them is People v. Flaherty, 165 Mishap 113. I'm sorry to lay these on you right now, Judge, but this principle is pretty well established. It's not being offered to prove the truth of the matter asserted, but only to prove that, in fact, the city thinks they're going to take action against my client. And that goes to the motive of my client in wanting to continue to pursue this termination. There's no evidence of a rental agreement. We haven't alleged a rental agreement, but we have alleged possession. We have alleged the violation of the law, and we can terminate this tenancy for any reason, and we choose to do so at this time and ask for the court to enter a judgment on our behalf. Thank you, Judge.
Thank you. Mr. Chapman, as to your assertion that there are triable issues before the court, your argument, please.
For one, I agree with him that there is no record of, it was a verbal agreement, okay? I do have issues to present regarding the cleanup in there, the unpacking. It was a storage unit, okay? And that the unit itself has never been rented. Therefore, he has no previous amount for it. I was contracted verbally to build engines for Mr. Brown. Now, I also have a document that I would like to make a copy of and send to you of another engine builder's prices for stuff. And I just assume that there's going to be a lot of conflict here on the facts. And therefore, if there's conflict on the facts, there's a tribal issue. I also object to the fact that the man that has a felony pending against him will be admitted to give testimony in a Zoom meeting in the landlord-tenant case. And he's been the one that has resulted in most of these phone calls here. There is yet another case, and I would ask for discovery on this, that Officer Jeff Wickham of the Belleville Police Department has the film of Mr. Carrier carrying the pistons and rods out. That is currently before the Wayne County prosecutor. I would ask the discovery from that film there be allowed to be entered into the evidence in this case. I've also presented a tentative agreement that as soon as I receive my pistons and rods back, I've been continually after Mr. Brown on this, and I've just told the attorney, Mr. DePietro here, if I receive those pistons and rods back, I'll be gone in 30 days. I've already moved a lot of my stuff out. I just need a little more time and I'm gone. As far as that goes, I'll deny living there, and that would be a challenge of fact. It is unlivable. And I want testimony from people face to face that for cross-examination purposes too. And regarding the fact, I'm going to hold out to the fact that I'm going to argue that I have never lived there. I've never used that address as a residence, or registered to vote, or anything else. It's been a workshop, and that's what I've used it for. And that's what is in the service of Mr. Brown, by the way, and short pay and all the rest of it. But now when the neighbor Carrier wants in there where it's heated and has running water, a sink with running water, this has all happened. And for the record, I'd like to say that I'm the one that brought Mr. Carrier to Mr. Brown, and I'm sorry I ever did that.
Mr. Chapman, if it's your position that you don't live there and you've never lived there, what is the tribal issue of fact as to the complaint to recover possession of the premises?
Well, the thing about it is Mr. Brown allowed Mr. Carrier to carry out my property about $5,000 or $6,000 worth of pistons and rods. And until I get those back, I'm going to continue to pursue this and defend against it. And once I do get them back, property is turned back over to him in 30 days.
May I respond, Your Honor?
Yes, Mr. DePietro. I'm sorry, before you do, Mr. Chapman, did you have something else? Some other argument as to there remaining a tribal issue?
Yes, there's a lot of facts that have to do with the door locks being spiked, you know, especially before the agreement was done, the 30-day agreement. And put it this way, I was kept from being fulfilled on the 30-day agreement on the last 3 days by the door lock being spiked. And as far as I'm concerned, Mr. Brown knew about it. It was probably Carrier that did it. And if it goes this way, I'd just as soon go to trial on it and be able to present all my stuff, because I'm out $5,000 or $6,000 worth of pistons and rods that were mine, not Mr. Brown's, that were inside, and Mr. Brown let the man in. this is one of my sole complaints on this. I'd want to wash my hands of this. Otherwise, until I get those pistons and rods back, I'd appreciate going to trial, Your Honor, for a jury. And I contend with all the facts that he's putting up.
Anything else, Mr. Chapman?
Not at this moment, ma'am.
Your response, Mr. DePietro.
Yes, Your Honor, I think Mr. Chapman has made it very clear that the question of possession is going to be held hostage to a damage claim that he wants to bring to the court so that he can obtain money damages for alleged theft by Mr. Brown, who is available to deny that if the court thinks it's important, and that he's not going to let go of this until he gets his pistons and rods back. And I would suggest the landlord-tenant court is just not the proper place for that. I heard no defense to the request for possession, and my client is available to back up my argument should the court need it. And he is also available to answer any questions this court might have. And I renew my motion. Thank you, Judge. Could you hear me, Judge?
I did. I heard you,
Okay.
Mr. DePietro. Thank you. Mr. Chapman.
As far as that goes, I think I'm owed money for rebuilding the engines, and Mr. Carrier could not have gotten inside that room without Mr. Brown letting him in through the front door. So therefore, Mr. Brown was there. And when this is the first time they changed the door lock and avoided going to court over this and doing it properly, they just changed the locks, and they've been messing with that door lock all the way through there. And they don't want to talk about this. This is part of the facts that I want put before the trier of fact. And Mr. Brown has a history of changing door locks on people. There was a funeral director that he's done this to before. And I'm certain that I want to get my issues before a jury, and they either deny or ignore them. The point I'm trying to make is I'm ready to walk away if I get my pistons and rods back and get 30 days to get the remainder of my property out of there. And I've been working steadily on that every day.
May I respond to the new issue, Judge?
The last thing, Mr. DePietro, yes.
I gave him keys to the premises on November 18th, 2020. And ever since that date, my client has
I'll
been.
respond.
No, Mr. Chapman, you will not be responding. Mr. Petro is having a response to what you just raised. Not that.
Ever since that day, my client has been barred from the premises by Mr. Chapman, welding the door, cutting hinges, and otherwise prohibiting entry of the landlord. And Mr. Brown is available to buttress that. And that's only offered in rebuttal, Judge. I don't think it's necessary in my case in chief. Thank you, Judge.
I have a response, Your Honor. The doors have not been welded shut. They have been secured in order to keep some more of my property from walking off. Before you issue an order, which I will obey, and hopefully it'll be a 30-day order, whether or not I get my pistons back, I am full able to comply with your order. But every time something happens here, I've got a door on there with a keyless entry I had to put on there. And Mr. Carrier, I believe, came back there, spiked the key lock, broke the keypad out of it, and now I've got the only way in and out I've got is a key fob, and it works just fine, and none of my stuff has been stolen. They violated every agreement with me and have failed to come to the legal ramifications of this until now, when they couldn't get me out of there illegally. So what I'm asking you for is to get discovery from the larceny case of Jeff Wickham of the Belleville Police Department. Get the video of that man taking those pistons and rods out of there. And I'm asking for discovery for this case because it's directly relevant. If my landlord did not protect my interest and instead let someone else in there, I must have some kind of recourse. And I look to you for that recourse, Your Honor. So what I'm asking you to do is to see if you can't investigate and find out what's going on here for real. Mr. Brown has denied, and Jeff Wickham was the one, has denied giving over the cameras of Mr. Carrier spiking the locks, going over there and beating on the door, and just plain being obnoxious. So I'm going to ask you to grant discovery so that we can find out what's going on here.
Anything else, Mr. Chapman?
No, ma'am.
Anything else, Mr. DePietro?
I agree with him, Judge. He should have all those rights in a damage action that he can file where he can make specific allegations and prove them, but not in this case. This is about possession. Thanks, Judge.
The matter before this court is purely the plaintiff's request to recover possession of its premises, not Gene Carrier or Officer Wickham or transmissions or pistons or rods. The sole issue is recovery of the premises. Mr. Chapman, I made it clear at our original hearing and when we started the proceedings this morning, that my question to you was about what tribal issue you believe remained, and you have been unable or unwilling to set forth what you believe to be a tribal issue.
Financial agreements, Your Honor.
Mr. Chapman, that's not what's before the court this morning. In reviewing the file, what I have is a notice to quit to recover possession of property from David C. Brown to James Chapman, and that is in fact dated, certified that on October 30th, 2020, that Mr. James F. Chapman was served by first class mail a copy of the notice to quit to recover possession of property, which provided that you needed to move from the property, that the plaintiff was in fact seeking to recover the property. Subsequent to that, there is a complaint that was filed on December 29, 2020. That indicates that there is no other pending action between the parties regarding this specific transaction or occurrence. That David and Martha Brown are entitled to the possession of the premises and identifies it as the southeast portion of building at 668 East Huron River Drive in Belleville. That the plaintiff has a right to possession indicates that the defendant is violating local laws by residing in a garage zone for business. But from the court's perspective, you were given proper 30-day notice to terminate the tenancy. And although there is no written agreement between the parties, it's assumed that it's a 30-day and that you've received notice that that 30-day agreement was terminated and you have not removed your property. You have not set forth a tribal issue as to a termination action. For that reason, the court is going to grant the plaintiff's motion, find that there is no tribal issue of fact, and indicate that pursuant to MCR 4.201 sub J sub 2, that there is no tribal issue and the court must in fact enter judgment at this time. If Mr. DePietro submits a judgment to the court that comports with that order, with my statements this morning, that judgment will in fact be entered.
Your Honor, Mr. Chapman asked me to have you repeat the court rule for his benefit.
4.201 sub J sub 2, which specifically provides at trial, the court must first decide pretrial motions and determine if there is a tribal issue. If there is no tribal issue, the court must enter judgment. And while Mr. Chapman, I understand and respect the issues that you're raising regarding property and Mr. Carrier and any other actions that might be pending or might be being contemplated, that is not part of the summary proceeding termination action that is before the court this morning. So my rulings and my statements are based purely on the complaint to recover possession of premises filed by the Browns in this matter.
Thank you, Your Honor.
Anything else, Mr. DePietro?
No, Your Honor, thank you. I'll submit the order today, and I'm letting Mr. Chapman know I'll submit it today.
Anything else, Mr. Chapman?
Yes, Your Honor. I contend that the money between me and Mr. Brown has everything to do with how much more rental time I have coming. Okay? And I've made that pretty clear about what's happening. I know Mr. Brown wants me out. I've given a proposition for me to get my pistons and rods back and be out in 30 days and dispose of the case. But it's over the money that Mr. Brown owes me for building his engines, and these are tribal facts. Okay?
They might be tribal facts, Mr. Chapman, but they're not tribal in this termination of tenancy action.
Well,
So
it's got-
respectfully, Mr. Chapman, respectfully, I'm going to disagree with you that, and I do not believe that this is the correct form for what the issues you are trying to raise.
Your Honor,
Mr.
I'm gonna
DePietro.
take, Your Honor, I'm gonna take an appeal, and I would like a stay of further proceedings pending the appeal.
Mr. Chapman, in as much as we haven't even entered the judgment yet.
Okay, I'll wait.
Thank you. Anything else, Mr. DePietro?
No, Your Honor, other than what might come as a result of the appeal. I'm fine, thank you.
Understood. Thank you very much. Have a good afternoon.